All right, we're about 3 minutes past the hour. Why don't we start? Welcome, everyone. Thank you for joining us. This is the next in our monthly series of webinars that Venable's Advertising Law Practice presents to you. Really pleased that you could be joining us. Sorry that it couldn't be in person, but we will be talking today about state attorneys general and consumer protection. And this is a really important topic for a lot of our clients. It's a topic that we visit every so often, and it is particularly timely and relevant today for reasons that we'll talk about in a few minutes. But basically, a recent Supreme Court decision inhibiting some of the remedial relief that the primary federal consumer protection regulator is entitled to, the Federal Trade Commission. And so we're expecting as much, if not more, activity out of the states, and that's what we will be talking about today. I am Eric Berman. I'm a partner here in Venable's Washington, D.C. office. I practice in several of our groups, including ad law. I practice with our nonprofit folks and our postal folks, and do a lot of work representing clients in state AG investigations, FTC investigations, and other regulatory litigation and private litigation. I am thrilled to be joined by my friend and partner, Eric Jones, the other Eric, the better Eric. Eric recently rejoined us, and so we welcome him back to Venable, and he's in our Chicago office, our newly opened Chicago office. And in addition to his private practice experience, Eric has tremendous public service experience under his belt. He was the chief investigative counsel to the Senate Commerce Committee. He was counsel to the House Oversight Committee. And I think most importantly for today's discussion, Eric was the Assistant Attorney General of Illinois. And so we have some slides to guide our discussion today, although I think that they will be largely guidance, and Eric and I will sort of riff off each other for much of this. We are offering CLE credit for today. You get an hour of CLE, and here's the slide. Roughly at the halfway point, Eric Jones will provide you with the super secret CLE passcode. But we will not give it to you now because we want you to hang tight. Also, we'd like this to be as interactive as you would like it to be. So if you have any questions, drop them in the chat. We will try to address them during the webinar. And even if we can't do that, we will make every effort to follow up with you after the webinar and provide answers to your questions to the best of our ability. So why don't we just jump right into it? You know, some of this is basic stuff, and I suspect a lot of you know some of this, but we'll sort of just start at the beginning. I mean, state AGs are the chief law enforcers of their respective states. Pay attention to them. They have very broad authority to investigate conduct directed at their state or impacting consumers in their state. And I know that for a lot of our clients, federal regulators like the FTC loom large. There's a very active private plaintiffs bar that our clients have to deal with, especially in areas like telemarketing and food advertising. Of course, your competitors can challenge your advertising. In a few slides from now, we'll actually talk a little bit more about the universe of watchdogs and consumer protection enforcers. But state attorneys general are key. Every state, plus the District of Columbia, has its own consumer protection law. They are generally modeled after Section 5 of the FTC Act. We sometimes refer to these as, you know, baby FTC Acts or little FTC Acts, or more broadly, UDAP laws, unfair or deceptive acts and practices laws. And you know, I think one of the keys here is that while there is general alignment between the FTC Act and state UDAP laws, there's not often total alignment. State laws are often more stringent They are not preempted. And Section 5 of the FTC Act is written very broadly, and I think intentionally so. It merely prohibits unfair or deceptive acts or practices. And what that means has been shaped over the years by guidance documents and trade regulation rules and policy statements and things like that. Some state UDAP laws go in the opposite direction and actually specify a long laundry list of practices that are unfair or deceptive, sometimes dozens of them. And so, we're talking about an enforcement regime where some states have very broad consumer protection mandates. We've cited Utah's law here because it captures conduct, whether it occurs before, during, or after a transaction. Not on the slide, but I should mention, some states provide for supplemental civil penalties, right? So, I had some litigation involving the Minnesota Attorney General, for example, where, in Minnesota, if the AG can show that you violated its false advertising law or its consumer protection laws, and that you knowingly targeted senior citizens, you're on the hook for additional supplemental penalties. And of course, there are some laws that target specific industries, telemarketing, charitable solicitation, privacy, and the like. Remedies: every state authorizes its attorney general to seek court orders enjoining violations of their UDAP law. Most states permit attorneys general to seek restitution or civil penalties. Sometimes that's based on the number of violations. Sometimes it's tied to the amount of consumer harm. And finally, state AGs can also bring consumer protection lawsuits as parents patriae, literally father of the country, where they step into the shoes of natural citizens in their state and sue on their citizens' behalf. And we see that in consumer protection litigation, antitrust litigation, and others. Eric, anything to add, or should we move on to the next slide?
Just a couple things to add, and first, let me just say thank you for the introduction, and it's also a pleasure to be working with you again. It's great to be back part of Venable, and great to work with you specifically, and work with another Eric, even if you are Eric with a C. But we can talk about that another time. I think you covered it. I would say I think what I'll be doing is only reinforcing what you said on this, which is, one, as a starting point, if you're thinking of state AGs, think of very broad authority. Like the FTC, they have very broad consumer protection authority with their state UDAP laws. And so that allows them, and we're going to be discussing this throughout the webinar, it allows them to get involved and engaged in a number of different areas. But along with that, I think it's also important, and I'm glad you mentioned this. Each state, state legislatures, they like to tinker with their laws. Every session they're coming back and they're thinking about responding to different constituent concerns or whatever issues have popped up. And so every state takes their own sort of bite at the apple, so to speak, and they're always doing something unique. And so I think it's also important to note, which you did, that every state's a little different. And when you're dealing with an issue, it's very important to understand what the law is in that state. And maybe it goes without saying, but I think it's always important to just make that point, because there are differences and they do matter.
That's absolutely right. I mean, sometimes we do 50 state surveys for our clients, and sometimes we get these questions. Our clients operate nationally. I mean, hardly anybody operates just regionally or limited to one state. And so, and I think we know this, there are certain states in particular. California comes to mind, Massachusetts, I would say your domicile, Eric, and even where I am here in DC, particularly aggressive states where, compliance with the FTC standard does not necessarily mean compliance with the state law. So why don't you drive on this one, tools in the state AG toolbox, of which there are many.
Right, great. I'll walk us through it, and then you should absolutely jump in too. So what we're doing here is just walking through how can a state AG address a perceived issue on consumer protection? What tools do they have at their disposal? And State AGs are unique, and when you think of other regulators that are out there, because they both have enforcement authority. They have enforcement authority because they're oftentimes the chief law enforcement officer of a state, but they also typically behind the governor are the second most well-known politician in a state, and they have a fairly significant bully pulpit because of that. They also have informal power that we'll be discussing, and the ability to move policy and legislative issues too. And all of these different roles they play and these different sort of powers have an impact on what tools, as we're sort of talking about, come into play when they're looking to address some, and I say perceived because you never know if it's real or not, but some consumer protection issue that has come their way. And so what do these tools look like? Well, first off, we have what we describe as informal information requests. And that can literally just be a letter that the office sends to a company, to a number of companies at one time. It can be a survey. It can be a prelude to what will be something more formal, which would be a civil investigative demand or a subpoena. I've drafted these letters myself. They can be for various reasons, and as we'll discuss throughout the webinar, it's important to understand why that letter came. Sometimes the office is just trying to get more information. Sometimes it is the beginning of what might be more formal investigation. Secondly, are the formal investigations, which are civil investigative demand and subpoena authority, which is it's the AG's the office's power to compel both documents and testimony. They can issue these on their own. They don't oftentimes need to go to court. They can just put it out there. And as we'll discuss this a lot today, but how you navigate that subpoena and the back and forth you have with the office is a big part of what Eric and I do, frankly, because these things can end up they can start very broad. You need to work on narrowing them, et cetera. But the CID is sort of, I would say, possibly if you had to say what's the most important tool, that might be the most important tool that they use, because that's how any formal investigation, that's how it would begin. And that's how they build their case. But we also need to mention a number of other places where they can have an impact. These include public hearings, studies, workshops, and reports, and comments to federal proceedings. And this is what I was getting at when I discussed sort of some of the other roles they play, which is sort of the bully pulpit or pushing an issue that they think needs to be addressed. And maybe the only way to do it is not through an investigation and a settlement with a company. Maybe there's a sort of a broader issue at play. And they do that. They will put out reports. They'll hold hearings. They'll also band together. This has increased a lot in recent years. They'll band together and provide comments to something happening at the federal level. Sometimes it's bipartisan, where you've got something that's just a state issue, and a lot of AGs come together, whether Republican or Democrat. You also have increasingly Republicans coming together to discuss concerns they have with a Democratic administration and vice versa. And something also I wanted to mention, which I think Eric will talk about a little bit as well, is just the consumer education role that the offices have. I was involved in this myself when I was in the Illinois Attorney General's office. We tend to think of, or you can fall into the trap of thinking about the work that AGs do just as reactive, where there's some problem and they just want to enforce a violation of the law or investigate the violation of the law and then enforce it. The statute. They also, these offices serve a lot of functions within a state, and one of them is educating consumers and businesses on issues that are relevant. I mean, these attorneys general, they have constituents. They are elected officials. They want to be serving the needs of those constituents as they should be. And one place to do it is through consumer education. And so that's a place where they're much more proactive. And we mention it because a lot of you on sort of watching this webinar might be thinking that, well, we want to just keep our heads down and hopefully AGs never call. Well, there are also opportunities to get ahead of anything and to work with AGs offices in a proactive way. I've seen businesses do that. There are a lot of paths forward in order to play a productive role ahead of time, as opposed to just waiting for some newspaper article to drop and then lead to an investigation. One place I'll say that when I was in the office, something I did, we did a lot of data security work for, this was when a lot of the data breaches were happening. And we were going around the state doing sort of seminars for small businesses and medium-sized businesses to help them on how to improve their data security. So not only was the office investigating data breaches and seeing if there were violations of Illinois law because there wasn't reasonable security, the office was also trying to get ahead of these issues and trying to prevent data breaches in the first place. So that's an example of that. Eric, is there anything you would like to add, or that I missed?
I think you nailed it. I would probably say that the bullet that says consumer education, as you hinted at, Eric, should probably be consumer and business education. And I've heard from many friends in respective state AG offices who promise the business community, we're not out to just play gotcha. We really do view our jobs as helping compliant businesses do their jobs even better. I'll also just say informal information requests, as Eric said, could be a letter, it could be an email, and it could come from an attorney, it could come from a non-attorney, it could come from an investigator. Just because they're informal, don't ignore them. I think you want to wrap those up in a little bow and make sure that they're closed out before they escalate. Formal investigations, this is all pre-complaint discovery. This is not like dealing with a private plaintiff where they get to take discovery of you, you get to take discovery of them. With state AGs and other government regulators, it's really a one-way street until the complaint is filed. So a lot of this goes, one way, and it's a lot of documents and testimony and things like that that you have to give over, but we can't get from them in return.
Eric, you reminded me of something. Can we just where we can stay here? But I would just want to mention,
Absolutely.
And I think we'll talk about more about this as we discuss sort of how to respond and what that looks like. It's the notion that it's sort of not you should not think of it as civil litigation discovery. If you treat it as litigation and it becomes very litigious, that can break the wrong way. And I wanted to flag that at the outset.
Absolutely.
A good point to mention.
And we call this consumer protection oversight and kind of identified some of the players in a schematic. And I know you prefer to call it something else, Eric, maybe like the ecosystem, but what are your thoughts here?
Oh, sure. So, it's funny. I'll just say that. So Eric had developed this visual to sort of describe where state AGs sit and what role they play with consumer protection. And I think it's a great visual because I think it captures how significant of a role they play when it comes to sort of consumer protection. What I call it, and I think this is a great way to describe it too, but I myself have just come up with the term the consumer protection ecosystem. So to describe who the players are within that larger ecosystem, and how if you're talking about consumer protection, you have to talk about all of them because they all play a role. And there's state AGs, there's Congress, there are federal regulators like the FTC, but there are others. There are local prosecutors. There are also watchdogs or consumer advocates. And the development or focus on a consumer protection issue, all of these entities play a very important role in that. And it's important if you're thinking about that and thinking about risk, it's important to be thinking about all of these entities. And I will tell you, as Eric mentioned at the outset, I was initially when I was in government, I worked in the Congress doing congressional investigations and some other things related to privacy and security. I had moved in on the House side, then I went to the Senate Commerce Committee, which the Senate Commerce Committee has sort of jurisdiction over consumer protection in the Senate. And during that time and that work, I increasingly realized how critical the state AGs are to the consumer protection ecosystem. And it's for a couple reasons, but what I found over and over again was that the state AGs were often first or at the forefront of any consumer protection issue. And if you really want to know where the country is heading on issues, go to the state level and go to the state AGs, because they're probably first, and it's because they're receiving inquiries or complaints or calls from their own constituents. There are a lot of reasons that we're going to be discussing. But the point is, the visual with the state AGs in the middle, in my opinion, it makes sense because they really are critical to this entire ecosystem, and they're often moving first. And that's one of the reasons why I went to work in the Illinois Attorney General's office, and that was the experience that I had.
And just to build on a point that you made in the last slide, Eric, this schematic goes both ways. In other words, proactively as opposed to reactively. So it's not just, this doesn't just identify the players from a law enforcement perspective, but the players to whom you have access, our clients. If you are troubled by an industry practice, if you are troubled by a competitor's conduct, and sometimes we have clients come to us and say, I don't like what my competitor is doing, and they're engaging in deceptive advertising, and it's hurting our business. We want a level playing field. Can we put in a complaint to the FTC? Well, sure, but consider the state AGs, and consider trade groups, and consider people with big megaphones who can shine some light on this as well. These are all arrows in the quiver, offensively as well as defensively. So we got a question, and I think the question is perfectly timed, because the question was basically, what's the impetus for state AGs issuing information requests or starting investigations? And I think that segues nicely into this slide, which largely addresses that. How do AGs find you? Let us count the ways. There's quite a few of them. Consumer complaints are key. I tell clients all the time, consumer complaints drive regulatory investigations. Sometimes the best course of action is to resolve a consumer complaint quickly, make the consumer whole, even if you don't think you did anything wrong, because the headache, if the consumer is not bluffing and does go to their local AG, is probably more than it's worth. Consumers can easily complain directly to AGs. AG websites have 800 hotlines. Filing an online complaint is quite easy. There's the FTC Consumer Sentinel. The FTC, this is a database, basically a consumer complaint database. It's quite extensive. The FTC manages it. It is free and available to any federal, state, or local law enforcement agency. And I know that state AGs access it, and I know that they get some of their ammunition from it. State AG lawyers and investigators scour the Better Business Bureau websites. They scour what we call gripe sites, consumer complaint sites, ripoffreport.com and the like. Some of them are a little bit more colorfully named, like pissedoffconsumer.com, but you get the point. And all of these other bullets identify ways that AGs find you: disgruntled former employees, other insiders. I've had outreach from state AGs who were contacted by a recently terminated board member of a nonprofit, for example, and there was a complaint that they want to track that down. Competitor complaints. We'll talk about media in a second, because I think Eric has some thoughts on that. I do just want to mention referrals from other law enforcers, and that could be from really any other law enforcers, other states, other federal enforcers, and by statute, 15 USC 46, the FTC is allowed to share non-public investigatory records that it has compiled with state AGs, so long as the states only use that information for their own law enforcement purposes. So the laws kind of anticipate this type of information sharing and encourage it. Should I go on, Eric?
I was going to say, I can add a few things, just a couple of thoughts. I think you covered it well. It's interesting that we had a question right before this, because it's a very good question. I would say that the AGs really they're very responsive to consumer complaints. There are people there are people their jobs are to answer hotlines within these offices, and state AGs want to be very responsive to constituents, and they will have a good sense of where things are heading if they start receiving multiple complaints about the same practice. And that's the kind of thing that can lead to an investigation. So it's very important, as Eric mentioned, to work to address complaints. I think that is very good advice. That's what I'm advising my clients. I did want to reference local media. We think a lot about, the Today Show and 60 Minutes and, the nightly news as places where you certainly don't want your practices highlighted and in a negative fashion, right? And I completely agree with that. As it relates to AGs, you also can't ignore the local media, because if, some local TV affiliate calls the AG's office, and ask if they're going to do an investigation into some issue that some individuals complaining about, the likelihood of the AG office saying that yes, they're doing an investigation goes up dramatically.
I think that's a great point. And I actually forgot to mention something, and I'll just mention it quickly. Competitor complaints. Perfectly legitimate to bring a competitor complaint to a regulator, federal or state. I tend to counsel clients that the best way to get some traction is to couch the complaint in terms of consumer harm. If you couch it just in terms of, what these guys are doing is hurting my business, I think that's less likely to get traction. So you really want to, this is an industry-wide thing, or it's really hurting consumers in your state, if you want to garner some attention here. And, kind of just moving along, that's how AGs find you, but, they don't have unlimited resources to go after every complaint that they receive. So they have to prioritize. And, this slide kind of summarizes, I think, some of the case criteria and some of the boxes that get checked when staff is deciding whether to use limited resources to issue a CID or even just an access letter and eventually file suit. What type of injury are we talking about here? Is there significant monetary harm? Is there a risk to public health? What are the characteristics of the victims? Are they predominantly part of a vulnerable population like seniors or children? Sometimes it depends on the time of year. Every year around Veterans Day, charity regulators housed within state AG offices issue press releases warning donors not not that it's not to donate, but to be leery of charitable solicitations purporting to raise money for the vets, when that conduct is not always on the up and up. What's the severity of the conduct? Is it a speeding ticket? A technical non-compliance with a requirement that's easily remedied? Or is it a homicide? Is it repeated, blatant, hardcore fraud by a recidivist marketer? And sometimes, the industry that you're in matters. Some industries are just at or near the top of the list of enforcement priorities for AGs. And I think we actually have a different slide on that, but the Utah AG's office, for example, goes after business coaching a lot, income generation operations, debt relief is big. And sometimes if you're in a high risk industry, we have clients ask us, how come they went after us? And the unsatisfying answer is, it was just your turn. And that's the unfortunate truth of it. Any other thoughts, or should we move on?
Yeah, just a couple. I think you covered it. Oh, and Eric, can you put your speaker on mute when I'm talking? I'm hearing.
Oh, sure.
There we go. So just a couple other things. One, vulnerable populations, a very good point. The Illinois AG's office had a veterans bureau focused on issues that were impacting veterans, for example. Senior citizens is a focus. Workers' rights has been a focus, which we'll talk about a bit more. Also, if is there outside pressure to open the investigation, rightly or wrongly, that can have an impact on the likelihood of a state AG opening a case. As I mentioned, to the local media issue. And then just something else to think about, and I'll put in the context of data breaches, which is something I deal with a lot, representing a few clients right now on data breach investigations with AGs. And is it and the data breach is a good example because if a data breach affects 30 people, the likelihood of the office opening investigation goes down dramatically unless there's some egregious example of a data security failure, right? But if it's a data breach that affected 15 million people, even if the company was doing everything right and had very reasonable security, the likelihood the office is going to open up an investigation goes up dramatically just because of the sheer size and scale. And I think that can be applied to really anything. If you're talking about something that has affected a lot of people, even if the conduct itself, there are very good arguments to make that it wasn't illegal or problematic on the part of the business, the office might want to be double checking that for themselves, given the scope of it.
Absolutely, and I'm just going to unmute to answer a question that we got. Someone had asked, who are the local prosecutors, and so for example, the California District Attorney's Office is very active in either on its own or I think in conjunction with the state, bringing actions, under California's Prop 65, for example. But but we do see some of that at the local level across the country. And speaking of which, actually, so that's a good segue to talk about some state AG priorities, and I'll let you kick it off, Eric.
Great, thanks. And I will say, I want to share the CLE code. We're halfway through, I'd say. Hopefully the powers that be think I've given it enough time. The code is State AG 21. That is State AG 21. Doesn't matter if it's uppercase or lowercase. It's 50-50 on whether or not I have to be reminded, and I did not have to be reminded, so that's something. We're going to talk now about state AG priorities. As Eric and I have been discussing, the AGs have very broad authority, and this authority can mean different things at different times, frankly, based upon sort of what's happening in the market, what are issues that are clearly affecting consumers, what are issues that are in the news a lot that the country is sort of trying to understand how to respond to, whether it's because of action or attention in Congress or or think tanks, et cetera. And what we'll see is that sort of given their jurisdiction, that the AGs are typically in the middle of the sort of issue du jour of the day. Whatever is the big issue affecting consumers, they'll be right in the middle of it. A couple examples are, if you go back to the 1990s, you'll see the state AGs all over tobacco litigation and tobacco issues. In the 2000s, you'll see the state AGs all over and very much involved in all the sort of suits and investigations related to the financial crisis. And during my time in the office, there was a rash of data breaches that were affecting consumers. The state AGs were right in the middle of that. Now, what's the focus? Well, we've got antitrust as an issue. That's becoming part of a conversation on, and there are a number of investigations related to sort of quote unquote big tech. So if you find an issue that's affecting consumers and it's sort of a hot button issue, you'll find the AGs right in the middle of it. Now, they necessarily aren't always on the same side. You might have AGs taking different perspectives, and some doing an investigation, others AGs saying we shouldn't be doing this and this is fine. The point is they'll be relevant in some fashion. Other issues that are sort of popping up right now are healthcare, not surprisingly. Hospital mergers continue to be an issue or an issue that they're focused on. Opioids and other drugs are an issue, especially in those parts of the countries that are more affected by this issue than others. Price gouging has been a focus. Privacy and data security, as I mentioned, and then charity fraud, countering hate and discrimination has been a issue that's grown over the last year. The current president of the National Association of Attorneys General is the DC Attorney General Carl Racine, and he has made it his presidential initiative to counter hate and discrimination. And there are a number of other AGs who are focused on the issue as well. Workers' rights has become an increasing focus by the offices. Some offices maybe always did this work, but they hadn't sort of ever formally put together a bureau, and workers' rights bureaus have popped up in offices, sort of showing how dedicated the offices are to those issues. And I want to just sort of say that going back to my initial point, which is if there's some issue or some topic that's a focus of the country that you'll see state AGs involved, that will happen. But then I should mention that, and I say deceptive marketing for the end to make this point, which is there are some sort of meat and potatoes, as we describe it here, or bread and butter issues where they'll always be involved, the state AGs, and that will be something that they're working on. Maybe some issues will go up and down on their focus. There are some issues that they'll always just be doing if they come across something that they view to be a violation or to be deceptive or false advertising. And these, when it comes to consumer protection, that's something that they'll just always do. And that's really driven by, as we've already discussed, the complaints that are coming in and what they're seeing, or sort of what's being fed into the office. But that's an issue that you won't see that wane. That's sort of right in the wheelhouse of what it is that they do. Eric, do you want to add anything to that?
Yeah, just the fact that between meat and potatoes and bread and butter, I'm reminded that I haven't eaten yet. So thank you. No, this.
I was going with bread and butter in my own notes, and then I saw we called it meat and potatoes here, so I said I'll just mention both.
No, I think it's clear between us which one of us is not on the low carb diet, but no, this you've covered it, and honestly, if you go to the National Association of Attorney General website and click on consumer protection, I mean, you will see this is hardly an exhaustive list. It's, as Eric said, it's everything under the sun. It's telemarketing. So really just broad consumer protection mandate. But with that, we'll move on to the next slide, and I'll just kick this off. We kind of previewed this in the invitation to the webinar, the impact of a recent Supreme Court decision in AMG Capital Management versus the FTC, and what that means for state AG enforcement. And we don't really have time for me to bore you with the full history lesson, but at a 20,000 foot level, basically for the first 70 or so years of its existence, the FTC would enforce consumer protection violations by bringing administrative actions before administrative law judges that were employed by the FTC and getting cease and desist orders. And in the 1970s, Congress passed Section 13B of the FTC Act, and among other things, 13B authorized the FTC in proper cases to get injunctions in federal court. And the FTC didn't use it very aggressively right away, but in the 1980s, FTC staff really started using its 13B authority, and it started going into federal court, and it took a very expansive interpretation of its remedial authority, and the FTC would argue that under 13B, it could avail itself of the court's inherent equitable powers to not only get an injunction stopping the deceptive or misleading conduct, but other types of equitable relief as well. So including disgorgement of ill-gotten gains and restitution, basically equitable monetary relief. And for decades, various district courts and courts of appeals accepted this argument. And so, we've been dealing with this for years and years. The FTC will kind of just march into court. Sometimes it gets, even an asset freeze, a preliminary injunction followed by a permanent injunction, and significant equitable monetary relief. And more recently, courts in some circuits, the Seventh Circuit stands out, the Third Circuit, began pushing back on the scope of the relief that the FTC could get under 13B, and it ultimately went up to the Supreme Court to resolve a circuit split. And this past April, a unanimous court held that 13B does not authorize the FTC to obtain equitable monetary relief, only injunctions. Injunction is the only word that the statute uses, and we're not going to read more words than what Congress actually wrote. So, that obviously hamstrings a major law enforcement tool that the FTC was fond of using. I mean, pre-AMG, the FTC touted that it had returned, 10, 11 billion dollars or more to consumers under 13B. It had dozens of 13B cases pending in district courts at the time of the decision, and now defendants in those cases are able to kind of whittle down the case a little bit, and they might still be on the hook for injunctive relief, but not for equitable monetary relief anymore. But as we mentioned at the outset, most states authorize their attorneys general to seek either civil penalties or equitable monetary relief under state law. So, AMG is a big development. Everybody in the advertising bar and the consumer protection bar is aware of it and talking about it. And, the FTC is working with Congress to try to restore some of its remedial authority. But, in the meantime, when clients are asking us, to read tea leaves, the general consensus is that the FTC will partner with states as much as, if not more, than it has previously in order to avail itself of monetary relief where needed. Any thoughts, Eric, or should we?
Yeah, I agree with every point you made, and we're going to be jumping into sort of what that coordination looks like, and
right now?
I think this will only sort of move to increase it. Yeah. So I want to include a slide that talks a little bit about how the state AGs organize themselves. I think it's important to understand what this looks like in the background, because it'll sort of, if you're just following the news and you're seeing what they're doing, understanding how they're organizing themselves, I think will help sort of give you insight into the decisions that are made. So first off, the AGs is organized as you can be with 50 states. They've become increasingly organized over time. Really beginning, it really sort of went to a different level in the 1990s, as I already mentioned, with tobacco litigation. Some argue that that's where the AGs really sort of figured out that they can really be a force when working together. And they do this a few different ways. One, it's very important to mention the National Association of Attorneys General, NAG for short. I've always, whether or not NAG is a great acronym, that's for them to decide, I suppose. But NAG provides training for AAGs so that they understand how to use their authority, provides training on new developments. They also host conferences that are very relevant. As a attorney who practices in this space, I attend these conferences. They have a general conference. They have conferences solely devoted to consumer protection. These are places where you can get a sense for. Part of these conferences are public, and so the AGs that will be in attendance, the staff will be in attendance. There will be panels. These are places where you can understand and gain some insight into what the AGs are focused on and where they're heading. It's also an opportunity to engage with them, push back on places where you think that they're getting it wrong, or ask questions if you're trying to better understand what it is that they're doing or what their priorities are. I also want to mention that there are working groups that the AGs have, the AAGs at the staff level. For example, privacy and security, antitrust, other places, they'll get together once a month. They'll walk through the ongoing matters that they have. They'll talk about developments. I'm mentioning this just so you can understand sort of what kind of coordination is happening at the state level. if you're dealing with an AAG in one state, don't assume that that's just going to stay in that one state. There's a lot of conversation happening. I did want to mention sort of the political organizations that are out there too. These have become more relevant over time. There's the Democratic Attorneys General Association and the Republican Attorneys General Association. Of course, their organizing principles to get more Republicans or more Democrats elected, depending upon which organization it is. But they also host for individuals or entities that become members of the organizations. They host quarterly conferences, which also provide another opportunity, like the NAG conferences, in order to get to know the AGs, to get to know their priorities, to understand what it is that they're trying to accomplish. For a lot of reasons, it's a worthwhile investment of time for businesses that are interacting with the AGs, or any entity really that's interacting with an office a lot. Of course, if you're at the Democratic AGs conference, they're going to have a sort of a political bent to that on the Democratic side. Same goes for the Republicans. And then finally, it's just worth mentioning the Attorneys General Alliance, which is another organization. They host a meeting once a year that's well attended by a lot of AGs. And sort of started off originally it was sort of more focused on just the Western sort of AGs on the Western side of the country, but it's expanded, and now it's also another organization that's worth paying attention to for all the reasons I've already mentioned. Eric, anything else to add?
No, you covered that excellently, and I look forward to joining you at these FAGA conferences in the coming months.
I would say, for anybody, we'll be. I think we have to pick and choose because I think there's some overlap, but I think we will be at DAGA in Minneapolis in August, which they're going to be doing in person as opposed to just doing it virtually, which is what we dealt with before. And another one of my colleagues will be at RAGA. So we will be at both, and hope to see you there if you.
We are bipartisan. I do want to mention we're sort of 50 minutes past the hour, but I would prefer being interactive than just reading slides. And somebody asked a question about a trend of AGs going after entities maybe up and down the chain, but not the alleged wrongdoer directly. But second tier parties, perhaps in situations where the alleged wrongdoer is bankrupt, and so there's and what do we think about that? And that's certainly at the federal level. That's not new. We recall Operation Choke Point, which was something that DOJ did for a while. Doesn't really do it anymore. Where it would bring cases against payment processors who worked with wrongdoers in order to, as the name implies, kind of choke off the funding to the wrongdoers. The FTC doesn't have aiding and abetting statutory authority, but it does rope in relief defendants sometimes, or sort of network affiliates of alleged wrongdoers, especially in telemarketing cases. So that is something that we see. Absolutely correct. We're seeing it at the state level. I would expect that to continue. I don't know if you have any thoughts on that, Eric, but if not, I could certainly move on.
I think you covered it.
Yeah. So, for time-saving purposes, we can sort of group the next three slides together. I think they all generally deal with coordination amongst the states themselves, and also between the states and federal regulators. And right, so we've spent a lot of time. How do the states coordinate, and what does it mean? And these slides are a bit denser in content, so we're not just going to kind of read them verbatim. But I would just note for this audience, this stuff isn't new. Multi-states have been around at this point 30 or 40 years. Federal state coordination has been around for years. I do think it's becoming more commonplace. When I was relatively new to Venable, about 7 years ago, the FTC partnered with all 50 states, plus the District of Columbia, plus about 8 secretaries of state. It was the first ever law enforcement action in the charity sector, going after sham charities. And that was a situation where coordination made sense. There were some synergies there because the FTC doesn't have jurisdiction to go after charities. States do. And so the states led that investigation, and when the fruits of that investigation led to a conclusion that these weren't legitimate C3 organizations to begin with, the states brought in the FTC. Sometimes it goes the other way. Sometimes the FTC brings in the states. I think apropos of the equitable monetary relief discussion that we just had, we could expect to see the FTC bring in states more frequently. But coordinated actions like that have sort of set a blueprint that I think has made it easier and more common for federal regulators and state regulators to coordinate. And we see the fruits of that now. I mean, just a couple of months ago, there was yet another FTC, and I think it was 46 state agencies shutting down another charity robocalling operation. I would just note the immense patchwork of regulators here. I mean, the ones that are on this slide are not exhaustive. You could add the Postal Inspection Service to this. You could add the SEC to this. Here we talk a little bit about what kind of forms this coordination takes, right? You could have multiple jurisdictions sharing resources to bring just a single action in one jurisdiction. Sometimes you see industry sweeps. You see the FTC partnering with state AGs. They're sharing resources, and they are bringing several contemporaneous actions in different jurisdictions all at the same time. You can go on the FTC's website now and read press releases where they are touting massive law enforcement actions, 40 or 50 at a time, and they're all different actions. And the FTC is the plaintiff in maybe 10 of them, and California is the plaintiff in a few, and some of them are multi-state, but they are all considered one overarching industry sweep. And that's been going on for decades, but I think we are seeing it with a bit more regularity now. I will say that we mentioned common interest privilege here. If you don't settle, and if you decide to litigate against a multi-state along with the feds, you can certainly take discovery of government lawyers. That's not prohibited. You will face the challenge that almost certainly they will claim an investigatory privilege, and if it's a coordinated action, a common interest privilege that will make it difficult to extract information from them during the litigation. Anything to add from your days in the AG's office before I move on, Eric?
Well, I could probably spend a lot of time talking about it, but being cognizant of where we're at, you did a great job covering, and there's a few other things I think we want to get to. So,
absolutely, and there's more of the same here. I mean, I will say, I think your mileage may vary. My experience is that when you're dealing with the FTC, for example, toward the end of the investigation, oftentimes a staff lawyer will reach out with a draft complaint and say, hey, I've got settlement authority for the next 60 days. Let's talk. And they don't just sort of run into the courthouse. Some states operate like that as well. Some states, Massachusetts comes to mind, have some sort of requirement of a demand prior to filing suit, but not all of them do. And I've been defense counsel in FTC multi-state coordinated actions where the states wanted to go right to court, and it was the FTC that was sort of pulling back the reins a little bit. and being more amenable to a settlement discussion. So if you are in the unfortunate position of being the target of a coordinated action, I think determining who's running the show and what tail is wagging the dog, and moving accordingly is a good strategy.
Absolutely.
This is all you, Eric.
Okay. So walking through how to respond to a state AG contact, or what that looks like. And I did want to say I got a question that popped up that I wanted to answer as well regarding. The question was related to the focus on privacy and security, and are there creative ways for state AGs, including smaller state AGs, to ensure that they have sufficient expertise and funding to enforce state privacy laws? And then so the follow-up was maybe related to special counsels, which I think is I'm glad someone raised the special counsel issue. We haven't raised that yet. State AGs will bring in outside attorneys, plaintiffs' attorneys, and sort of give them roles as special AAGs, where there's a fee, some kind of arrangement on fees, and if the plaintiffs, the outside counsel, and I should say too, they will hire defense counsel too, depending upon the situation. But state AGs will hire outside lawyers who have expertise in a specific issue that's maybe incredibly complicated and technical. If they view that it is a overall a benefit to the state to do so, and that does happen. As it relates to privacy and security, I will tell you what I've seen. I think at one point there had been, I think some of the settlements they got years ago allowed for funding for training for AAGs through IATP certifications. And there's been a lot of expertise built on privacy and I would say more, certainly on security, because that's been something that has been a focus of the AGs for some time with data breaches. And so the way they get around this is partnering together, and you see a lot of these multi-states, especially on the security side. On the privacy side, it's a little more complicated because now you're seeing states pass their own comprehensive privacy regimes, which I personally think is there are issues with that, because a patchwork with comprehensive privacy regimes becomes incredibly difficult. And that's also going to be putting a strain on states as well. And so, one way to address this would be have a national privacy law that allow the state AGs to enforce. But that's a different webinar, I think. I want to mention in response to a state AG sort of contact. I know we're running out of time. I'll go as quick as I can. It's when you receive contact from a state AG, it's important to understand sort of the context and how that came about. Is it, as Eric was discussing earlier, is it an investigator just responding to a complaint that came into the office and not at the AAG level? If that's the case, what can you do to resolve it as quickly as possible? So because really what this investigator has to do is they've got to close the file, right? If they can't close the file, there's a chance it pops up to the AAG, then you've got yourselves a full-blown investigation possibly. And not to suggest that may happen regardless, but that's something very important to understand. Also, whether is this a multi-state investigation? Is this just one state with a specific sort of issue at hand? And understanding all those dynamics are incredibly important. Litigation holds, of course, you need to, when you get the CID or subpoena, you need to put a litigation hold in place. And once you get that subpoena, look, there are outside counsel who deal with this on a regular basis understand that you can negotiate the scope and the timing and the deadlines of the subpoena. Typically, the AGs will start incredibly broad, knowing that there's going to be a narrowing. There's a way to do that now, but there's a right way and there's a wrong way to do that. I would say, in my opinion, the bad way to do it is to sort of go into the office and tell them that they're being abusive and that they're missing the mark and this is a terrible thing and you don't know what you're talking about and you shouldn't be doing this. Maybe there's a time and place for that, but and there will always be look, when the time comes to push back, you should absolutely do it. At the same time, it's important to sort of what can be more productive is letting the AGs know sort of, here's what I can get to you, here's what I can provide, And if you need more, and this is the time frame I can do it. If you need more, we can have an additional conversation. I found that to be a more productive path forward. Although I say there's caveats to everything, because sometimes if it is abusive, you got to make a point. We're running out of time. I did want to highlight one other point, which is, and I thought it was right to flag, which is sort of when you're meeting with the staff and the AG, there's always this, I think there's an inclination to say, well, I want to go straight to the AG to let him or her know about this, because we got to fix this. And, we have former colleagues who are currently an attorney general. Eric and I both know people at various levels all over the country. A lot of our colleagues do as well. If we need to make one of those phone calls to the front office, we can do that. But when you do make that call to the front office, you want to make sure that the timing is right to do that. You don't want to do it prematurely. You want to make sure you have sort of your story to tell. You have the reason for going up the chain, and you understand the ramifications of that too. I mention it because it does seem to come up a lot. And there's a time and place for it, but you need to do it in the right way. And Eric, I know we're over, so there's certainly some more information on this slide, but I want to be cognizant of everyone else's time.
No, there absolutely is, and I'm sorry that we went over. We have one more slide, and we don't really have time to discuss it. So I'll make what I think is the important point. Here Eric very ably talked about responding to a single state AG contact. If you find yourself in the position where you're dealing with a multi-state, whether it's 6, 12, 30, 50, and that can seem overwhelming. I think the key takeaway is you are not whacking 50 moles. Multi-states are typically run by an executive committee. In the charity case that I mentioned, it was all 51 states plus DC. I think there were 13 AG offices compromising the executive committee, but usually it's even smaller than that. It's 6 or 8. That is who you negotiate with. Focus in on singular points of contact who are reasonable. Some of this is very personality driven. Some people are true believers. Some people, are pragmatic. Some people are looking for a press release. Figure out your audience, work towards your audience. We could, as Eric said, we could talk about this all day. We have some questions. I commit our level best effort to get back to you with questions in the queue, and look forward to continuing the discussion. But thank you for your time this afternoon. Really great talking to you, and hope that we get to see you in person sooner than later.
Thanks so much, Eric. It's been a pleasure.
Pleasure was mine.